This is the big update in the ongoing retarded legal fight between Montagraph and me. And it is full of drama and intrigue and mostly just waiting because the law takes a long time. You have a couple different ways, of course, of doing different lawsuits. And most of the time, though, it's hurry up, get a bunch of shit filed and wait and wait and wait for the other party to file, for you to respond, for the judge to answer. And in between, there can be a lot of back and forth. There can be a lot of motion practice, or there cannot. In our case, there's not so much. So it's mostly about waiting and waiting and waiting. And boy, it's been a while. I think it was April 10th. April 10th, I think, was the hearing date. Was it May 10th? I think it was April 10th, which would make this about 90 days out, which of course is kind of how some of these things go. But we finally have an order. It dropped yesterday. Now, plenty of people have talked about it already. I don't know what any of them have said. I know what I have said. I know what my review of it is roughly going to be after skimming through most of it. We're going to read all of it on stream from start to finish, which is kind of what I do when we actually are following a case intently. And of course, like, I would not want to skip out anything in my own case. So we're going to go ahead and do that. We'll go through the whole thing. I'll give you my opinions as a preview. This is, it's not the best result, obviously. I would want this thing gone because it's a frivolous lawsuit. It's obviously been frivolous the entire time. And we'll get into the reasons why it's frivolous, of course, in just a little bit. But there are some interesting things about this order. And, there's a bunch of people who are out there, he lost or whatever. And sure, have that opinion. But this is also basically the judge saying, sorry, this motion is premature, and refile it at the close of discovery. Now, I have several disagreements with that statement. And there's a logical issue with the reasoning for waiting until discovery is closed, which we'll talk about to that spot in the lawsuit. But if the judge is going to determine that it needs to wait till discovery to close, then it's going to probably need to wait till discovery to close. There are options at this point. There is an interlocutory appeal because, of course, this denies pretrial relief that should maybe exist before. Interestingly, because a system designed by lawyers and perpetrated by lawyers exists and lawyers like money, running that appeal probably would run a similar cost to discovery and would risk delaying the case even further. And possibly, if it's unsuccessful, then you've got the issue of, well, now you paid for the appeal and you still have to do discovery. So what to do next is a big question. I don't know the answer to that. If I did, I probably wouldn't say it online before anything was filed anyway. But, so I'll talk about the different options there are, but I can't tell you what I'd choose because I have no reason to choose at this point. We don't even know how long discovery is going to be. And there's an interesting aspect to the discovery specific to this case, which is laid out in the order, which indicates that that is a very, very important facet of how this will go. But again, we're going to get into all of that in this. The judge has some very interesting statements in the order that I agree with and are actually quite favorable to our case ultimately. So, here's a thing that people tend to do. They tend to gauge their impressions of a lawsuit's progress based on the perception of the person, the party to the suit. And that's just the nature of things. We either want people to be in fault or not in fault, or we want people to win or lose. And so we decide that that's going to happen. The legal system doesn't work that way, right? The legal system works on this very interesting principle of a judge who tends to know very little, usually, about the actual parties involved. And that's the ideal, is that the judge doesn't know them at all. And then they take in admissible evidence and judge based on that. And then you have human conditions of judges and lawyers what the lawyers choose to include, what points they choose to argue, what strategic and tactical decisions they make in all of this. And then you have the other function where the judge has to decide which way to go. Judges get things right and wrong all the time. And sometimes they're big enough to appeal when they're wrong. And other times they're things you just got to roll with. It's all a question of a whole bunch of different factors. But this is the internet and people are going to say any number of things, and that's fine. But let's get a couple things out in the open. And this is something that's been going on from the very, very start of this lawsuit for me personally, which is several people seem to have the wrong idea of what a defamation suit defendant is and what a defamation suit's defendant roles and goals can be. So we're going to lay those out because I think it's critical based on the types of emails, the types of messages that get sent to me about Montagraph for people to understand just what is happening in this lawsuit for me. Montagraph is a consummate, gross weirdo with a penchant for threatening people online, up to including threatening killing multiple people, myself included in that, because he's a fucking weirdo. Like, you have to understand that that is who Montagraph is. He has a reputation for being a weirdo. In fact, pretty much everything I've said about Montagraph is based on his existing reputation, along with a couple jabs about him being a fucking weirdo. So all of that baked in, I understand that Montagraph is a menace to people online. These are the bulk of messages I have received, including phone calls from very terrified people who are literally afraid to give details, who are afraid to put their names on paper, but say that they will because they're actually afraid that Montagraph and some of his friends will murder them based on allegedly, and this is alleged, I can't verify this, but this is what people have told me, that they know people that Montagraph and his group of friends in the past have, say, driven to suicide. They call me out of concern that he will drive me to suicide. I'm like, Montagraph isn't going to drive me to suicide. He's a fucking retard. How could he do that? But that's that. Montagraph and his friends seem to have preyed on people who are prone to engaging in conspiracy theory. And when people engage in conspiracy theory and then some dope on the internet shows up talking about secret government information and like calling government officials on their home phones through whatever means he acquired them, they think that he might actually have some connection to cause them harm or undue pressure or stress or government action against them. Remember, they're engaged in conspiracy theory already, so they give extra credence to his threats and also extra credence to their importance in uncovering a secret government scheme. This is this weird hybridization of the internet, of people who are impressionable to various personalities, and how things work out with parasociality and all of that. So I have got it. I understand that Montagraph is a menace to all of you who have ever called me, who have messaged me, or whatever, asking me to personally somehow get Montagraph removed from the internet or arrested or extradited to, I don't know, Bulgaria or whatever by the government because I'm now in a legal battle and the judge can do that. But that's not reality. That's not a thing that happens. And it's not what a defendant in a defamation lawsuit is geared up or equipped or even as a realm of possibility of doing. I cannot in any way enjoin Montagraph from the internet as a defendant in a defamation lawsuit. No matter how many times he's threatened to kill you or me or Jack from Twitter or anybody else in an unhinged lunatic rant, I can't do that. The other thing that's really interesting about this case is, of course, all of the things that I'm alleged to have said about Montagraph, I believe are all recorded in public. And so there's this other portion of it where, like, Montagraph, his case against me doesn't really involve any extra information. All of it's there. And so there's this weird rumor going around that I'm taking down videos or something of me talking about Montagraph, which I don't know why I would, because all of the claims are in the complaint, and all of them except for I think one video or on my channel. The only one that I could think of would not be that's in the complaint is the one from Megan Fox, which I think is still up on her channel, at least on a Rumble channel, because I think that's where we were. But I don't remember. I don't think she was on YouTube at that time. But either way, it makes no sense for me to do that. So that is one of these things where someone needs me to be more of a villain for their own masturbatory purposes. I don't know what those are, but there's no reason for me to take anything down. I haven't denied, I don't think, anything that I've said or that I'm alleged to have said. I'm pretty sure they're all direct quotes from recorded live streams, which are all still up. It's just a very weird accusation. Now, allegedly, and I don't know, I can't verify this, but allegedly, Drummer, who has talked about Montagraph in the past and specifically has chronicled some of Montagraph's maybe less civil rants about wanting to murder people or whatever, he is receiving privacy takedowns from somebody. Now, presumably that would be Montagraph. I don't know if it is or not. I can't verify who sends a privacy complaint to whoever. But there's certainly no benefit in me taking down an unhinged rant of Montagraph. That doesn't make any sense. That would only be beneficial to me if this thing were to go on further. Now, there is a party that it is specifically beneficial to, but I'm not sure what videos I'm supposed to have taken down. All the videos I've ever recorded involving Montagraph are all up. And all of the archive videos, I believe, are also up. But I have no idea. So whoever has some weird fantasy about me doing that, okay, I guess. We'll see. It doesn't make sense. But so the role of a defendant in a defamation lawsuit is to do a couple things. To either deny that the statements were made, or two, to present whatever information that the statements are not defamatory. Either they can't be defamatory by law, or they didn't cause damage, or they can't cause damage, they're protected opinion. You know, there's any number of reasons why a statement might not be defamatory. So you either have to deny that the statement exists or deny that the statement is, fits the four elements of defamation. So my legal strategy is based on the second version of that, not on a denial of what happened. But the role of a defendant in a lawsuit is not to actually how do I word this? There are people who want me to uncover dark truths about Montagraph. That's not how defamation defense works. Because your defense of your statements, if you made them, right? Some people allege things that weren't said. But if you are defending statements that you made, your defense of your statements are based on the knowledge that you had at the time. So to try and uncover some secret from Montagraph's past now would be irrelevant to the statements I made back in October of last year. This is a critical misunderstanding that some people seem to have about how defamation defense works and all this stuff. It's if you could just uncover this. Well, no, all of the statements I made about Montagraph are defensible based on what I knew about Montagraph at the time. And again, so just again, for people who are very politely sending me stuff and encouraging me to do whatever, Montagraph isn't my dragon to slay. His defamation accusations are my hurdle to deal with. Someone else gets to go slay the dragon. I don't really fucking care. And the other thing that people need to understand is that outside of when like an order comes in my case or filing comes in my case or Montagraph is brought up by someone, I don't think about this guy. He doesn't exist. And he didn't for the most part between when I talked about him with Jim a couple times after that. And then for 2-3 years, like he didn't exist until he popped up again. And then he went away and he didn't exist until he sued me. And then he goes away between filings. This is not some guy that like I'm considering or pondering. He's a non-existent thing to me, as most people and things are. Like, let's be honest, I'm a self-absorbed asshole. So like, I'm not thinking about most other people unless they're directly in my attention. All of my bandwidth pretty much goes into building the nightly show. And since it's based on typically current things and current events and concepts, it's being updated daily. And then it goes into, having to deal with my kids' schedules. What does my wife need? What do I need to do? Are we seeing her parents or my parents or anything like that? What family stuff is going on? That's where my attention goes. So like, if you're not in that chain somewhere, you're likely not remembered. And that's not personal to you. I'm just kind of like that forever. As I've stated before, my dad said this once, and I realized how true it was for me. I've been working on it, but it's a hard thing to overcome. He says, when I get introduced to people, I hear my own name, meaning he doesn't hear theirs, right? It's like, hey, this is so-and-so. You hear your own name. Hey, Nick, this is so-and-so. Oh, hey, what's up? And often I hear their name as just some sort of blab or, Charlie Brown teacher or whatever. That's just how it's been. I guess, again, self-absorbed. But I'm working on that. It's a hard skill to like work or to build, believe it or not. But anyway, that being said, I don't think about much of this shit at all between stuff. That's why I hired a law firm to do it. And so again, any criticisms you have of any filings, please file with the complaint department of Mark Randazza. It's all his fault, Randazza! So anyway, all sorts of fun going on. But that being said, you have to go through the process. This is one other thing, and again, we'll get into the filing in just a second. There's one other thing people seem to misunderstand about lawsuits. There is no button to make something happen. It doesn't matter how frivolous or meritless something is. There is no thing where you go bloop and just turn it off. Like, here, judge, look, this is retarded, and they just do it. Like, there's no get out free button. It's a really, really crippling facet of the justice system in general, is that once you stand accused, there are remedies that come later for maybe something being brought frivolously. And those remedies are a maybe. But there isn't a way to mitigate the amount of fuckery you have to go through up to that point. There just isn't. So people are like, well, why? I mean, people have been asking for months, like, why is this still going on? It's like, well, I mean, you can't make a judge rule on something prior to them writing their ruling. And you can't make the motion practice not involve a filing of a motion, a response, and then a reply to the response. Like, that's just how it goes. There's no speed up button on that process. There's no shortcut out of it either. So that's the way these things tend to happen. And if you want an example of someone who suffered from tons of frivolous lawsuits and had to go through that process, just ask Josh Moon, the owner of Kiwi Farms, who's dealt with insane people suing him for years now. There's no way to stop him. It's beautiful. It's a great system, entirely fucked up. And again, there is occasionally remedies, but the person who sues you has to not be a complete fucking deadbeat. Whether or not that happens, well, luck of the draw, I guess. So here we go. Let me find this filing. Oh my God. Okay, so this is, of course, this is Steve Quest versus Nicholas Rekieta and Rekieta Law, LLC defendants. All right, so here we go. Here's the order. So there's the order, and it's followed by the judge's memorandum, which has the judge's reasoning for the order. This special motion to dismiss came on for a remote hearing before Judge Jennifer K. Fisher on April 10th, 2023 at the Candioi County Courthouse in Wilmer, Minnesota. Attorney David Schneider appeared on behalf of plaintiff Steve Quest, and attorney Mark Randazza appeared on behalf of defendants Nicholas Rekieta and Rekieta Law, LLC, collectively Rekieta. Based on the files, records, and proceedings, it is hereby ordered defendant's special motion to dismiss count one of the amended complaints denied. Oh no, Rekieta on life support. True. I am on life support. Please help me. Unplug it. Just unplug it. Defendant's special motion to dismiss counts 2 and 3 of the amended complaint is denied. Parties may move the court for summary judgment upon completion of discovery. Fun times. Again, we'll explain that in a little bit more detail and why I specifically disagree with this ruling of the judge. Now, before anybody gets weird and is like, Nick, you shouldn't talk about this, blah, 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 don't talk. I'm not disrespectfully disagreeing with the judge. I'm respectfully disagreeing with the judge. I completely disagree with this part of the ruling and with the denial of the complaint for the reasons that I disagree with or the denial of the motion to dismiss and summary judgment for the reasons that I disagree with this whole thing. And it has to do with what discovery is for and the role of parties in discovery. But that being said, my disagreement doesn't amount to shit. It's the judge. That's the way it goes. So I can disagree all day. And again, the remedy for disagreement, if I wanted to, would be to move for an interlocutory appeal and go after that part of the ruling. Is that worth it? I don't know. That requires a lot of discussion and analysis with my attorney. And the remedy of that may not be better than going through discovery anyway. And we're going to talk about why. This is the important part of that. We'll talk about why it may not matter. All of that's, like, I'm open to discussing it. I just can't tell you what I'm going to do because I have no idea yet. The attached memorandum shall be incorporated into this order. Memorandum. This is a case for defamation, as well as both intentional and negligent infliction of emotional distress. Quest claims that Rekieta made false defamatory statements about him over the course of 6 videos between October 2022 and January 2023. He asserts that in these videos, Rekieta insulted him using coarse language and slurs. Maybe slurs. And that Rekieta called him a pedophile. Did I use the word pedophile? I know I said sucking little boys. Well, anyway, Rekieta moves to dismiss on the basis of Colorado anti-SLAPP legislation, claiming that Colorado law is more substantially related to Quest's claims and that his lawsuit is frivolous, intended to chill Rekieta's speech. Now, this is an interesting facet of this decision. In that, I was not familiar with this sort of theory, this method of going after a different jurisdiction. Like, I'm familiar with conflict of laws and, the ability to bring in the laws of another state into a forum based on claims that pertain to the other forum. But I had not considered this as a possibility. This is Mark Randazza, whose firm has done this in other jurisdictions and prevailed. So it was interesting to see it as a legal argument that was proposed in my case. Certainly. And this is why, this is part of hiring someone who's an expert in the field, is they do things like this. And they've actually had experience and success with this type of strategy in other cases. Didn't work out in my case. Sucks, because it would have been cool if she did that. And that's dependent on a couple factors. Is the judge willing to apply another jurisdiction's law? Are they familiar with bringing in other jurisdictions' law? Do they make the correct analysis on it? Now, here's one thing I'm going to say about the judge. I wish she would have applied the Colorado anti-SLAPP in my case. Of course, it would have been a much more beneficial and swift outcome for me. Can I disagree with her analysis on this? No, I can't, because this is not something that I have legal experience in fighting. Now, I can disagree with it based on the premise that my lawyer raised it and I prefer and think his argument is a better argument for the outcome, but I'm biased there, right? It would be beneficial for me for my lawyer's reasoning to prevail versus Schneider's reasoning. Absolutely. But I can't actually objectively say what it should be in this case, and that I disagree with her on principle of some legal standing. I can't divorce myself from my own bias. To me, Mark Randaz's argument was more logical about why Colorado anti-SLAPP should apply and why Minnesota's lack of anti-SLAPP should not. But that being said, very, very biased. So I'm going to divorce myself from the legal analysis there. Like, I can go through the analysis, and she does in the order, and I could say, well, I disagree there. But as to what the result should be, can't do it with being objective on this one. On some other stuff, I could certainly be objective about it. And, but on this one, I can't. So I'm not going to sit here and be like, she's wrong. I mean, I want her to be wrong. If we appealed it, this would be part of it. And this is why it's one of the big things I have to consider in this appeal is, so to break it down, if we appeal it and win on this issue, then it has to be done under the Colorado anti-SLAPP standard, extremely beneficial for me. I automatically win fees back. Now, do I get those fees? No, but I get a judgment. I get a judgment that I can warn everybody else with on fees, and that's a pretty cool thing to have. It's a nice tool in the arsenal. But will I collect those fees from Montagraph? Probably not. The guy doesn't have, by all the current evidence, he doesn't have anything to take. And that's the big problem with America's legal system right now, is it doesn't matter if you have something like an anti-SLAPP or a fee shifting arrangement. If the plaintiff doesn't have anything to lose, then they can just file lawsuits all day. Look at, what's his face who sued Taylor Swift? Why can't I, the mouth? His name. I haven't talked to Russell Greer. Look at Russell Greer, Melinda Scott. You can win fee awards against them all day. There's nothing to take. These people will likely never amount to anything unless they were to win lotteries. Montagraph is even worse off because he's old. So he doesn't have he's not like 25 with nothing. A 25-year-old with nothing, you get a judgment. I mean, they may eventually get a job. They may become profitable. Who knows? Montagraph's I don't know, 93, 94 years old, something like that. It's a joke, Monty. We all know. We all know you're under 18, which is your defense. Shit. Am I allowed to joke about that? Can I even joke anymore? I don't know. I don't know. My speech is chilled. Anyway, Winston Smith says, how much of this opinion did the law clerk write? I don't know. So we're in a very small county. And one thing about very small counties is the clerks don't do as much opinion writing as in bigger counties. They really don't. They tend to only have one clerk. And so they don't do as much. In bigger counties with, bigger judges, you'll have several clerks that are working on stuff all the time. They're churning through cases. Out here, it's not like that. So I have no idea. But typically, yeah, you would have judges have clerks write a big portion of the opinion, a lot of the boilerplate stuff, and then they add some specifics or they'll tweak it or review it and stuff like that. I can't say on this one. I don't know. But seriously, the county seat of our county, the big town, to give you an idea of how little our county is, the big town is 21,000 people. And the total county size is something like 50 to 70,000 people. It's it's our whole county is not even the size of a suburb of a city, of a metro area. So when we're talking about scope of encounters in a courtroom, you have to understand just how small this county is. I live in the middle of fucking nowhere. Rekieta moves to dismiss on the basis of Colorado anti-SLAPP legislation, claiming that Colorado law is more substantially related to Quest's claims and that this lawsuit is frivolous, intended to chill Rekieta's speech. It is absolutely frivolous and intended to chill my speech. Absolutely. Both Quest and Rekieta have submitted flurries of evidence, almost all of which indicate that they were engaged in a vulgar online shouting match. Oh, yeah. That's just an online shouting match in general. Both called each other abhorrent names and made rude jokes at the other's expense. Welcome to the internet, baby. However, very little of the evidence on the record relates to an actionable claim of defamation, intentional infliction of emotional distress, or negligent infliction of emotional distress. That is a very bad line for Montagraph. Right there. The record has very little evidence related to those things. That's tough. Even so, claims of pedophilia are serious and are treated by Minnesota courts as a matter of defamation per se. Now, this is an interesting line. There's basically one case about this. And it's about, I believe, a police officer called Pete or Pat the pedo. Everybody called him that. And he had problems with his case too. But a lot of jurisdictions disfavor the idea that a mere accusation of pedophilia amounts to defamation per se. In many jurisdictions, they specifically say it doesn't. Now, Minnesota has scant case law on it, and that case law is old. The reason people called that guy that, by the way, is he was older and his bride was much younger. Although she was of legal age, I believe. But people called him that due to their age disparity. So the courts at that time found that pedophile was a defamation per se. There's a lot of argument right now that society doesn't treat pedophilia as defamatory per se, right? They're trying to become a protected class and all of that stuff. Like I said, lots of jurisdictions don't agree with that. But right now, that is the case law in Minnesota as far as the one case where it comes up. Whether or not that'll matter in this case is irrelevant. At this point, it doesn't matter. So here we go. Colorado anti-SLAPP legislation does not apply to the present case, and Rekieta is not entitled to summary judgment on Quest's defamation claim under Minnesota law. We'll get into why. Further, while there's currently a lack of evidence to support Quest's claims of intentional and negligent infliction of emotional distress, that's a bad line for Quest, a lack of evidence, it is improper to grant summary judgment here because the window for discovery has yet to close. Now, this is where it's going to get interesting. And again, I'll wait till we actually get to that section to talk about why this part is so weird. This is the weirdest part of this case. Therefore, this motion is premature, and Rekieta is not entitled to summary judgment on Quest's emotional distress claims. So this is, of course, the premature aspect of it can be brought again later at the close of discovery, as mentioned in the summary. While summary judgment is improper at this time, it may be reconsidered once the parties have had the opportunity to adequately develop the record. I would argue we have had the opportunity, but we'll see. We'll see. Both parties. Now, here is probably the most devastating line of this opinion for Montagraph. This makes Montagraph's case exceedingly difficult from this point on. Both parties have achieved relatively significant success as public figures on the internet. So a public figure question is a mixed question of fact and law. If Montagraph is a public figure, is a much higher bar to winning a defamation case, because he has to then prove that my statements had knowledge of falsity or a reckless disregard for the truth. There's no evidence that I have any reason to believe that anything I said about Montagraph was false. It's all based on stuff other people have said about Montagraph for a decade or longer. Montagraph being a public figure makes this case exceedingly difficult to win. In fact, outside of the Johnny Depp case, there are very few people who win a defamation case as a public figure. So that is a really tough line for him. Quest received attention for creating, directing, and publishing videos online through his YouTube channel under the name Montagraph. He also goes by the online username of October Reigns. His content ranges from potentially satirical and ridiculous to unsettling. Rekieta is an attorney who also produces content that discusses topical legal issues in the form of pre-recorded videos and video streams. Rekieta describes his content as commentary that aims to be both informative and comedic and compares it to late-night shock radio. While creating this content, Rekieta drinks, employs coarse language, slurs, and makes off-color jokes. Yeah, I think those more than the other stuff. Quest admits that Rekieta's content focuses on hyperbole and comedy. That, again, is a big, big problem. I mentioned that when we reviewed the complaint originally, that admitting the hyperbole and comedy aspect of this is kind of an issue for Montagraph. In his amended complaint, Quest identifies 6 instances in which he alleges that Rekieta made defamatory statements. First, Quest alleges that on October 6, 2022, Rekieta was a guest on a live stream, that would be Megan Fox's show, in which he made various false statements of a sexual nature about plaintiff. Okay. Quest additionally claims that Rekieta appeared in a video published on October 13th, 2022. I think this is on mine, which he accused Quest of pedophilia, asserting that he enjoyed sucking little boy cock. I think that's about accurate, at least. It's pretty close to the quote. In the same video, Rekieta stated that Quest should probably be shot in the fucking head. I mean, I'm not alone in that opinion, I don't think. Then calling Quest a child molesting fucking faggot. Bit harsh but fair. It's just fun when you get to have judges write stuff like that in an opinion. Shit. Quest further claims that Rekieta appeared in a video published on October 18th, 2022, which the host presented an image of Quest with guns pointed at him. Now that's an interesting, okay. That's an interesting wording, and my brain is fuzzy on how this happened. I remember the video, but it says Rekieta appeared in a video in which the host presented an image. Was I the host? Might have been on my live stream. I didn't make the image. It was someone in locals or something. I don't know. Quest with guns pointed at him. In another video, which I'm not aware at all that would ever be defamatory or intentional infliction of emotional distress. That's insane. In another video published on October 28th, Quest asserts that Rekieta accused him of making a snuff film involving a minor child in which Quest threatened the child both with sexual abuse and physical violence. Yes, that's referring to the Umbrella Man. And that has been a topic of discussion on the internet for quite some time. Extremely controversial. Quest knows that this is controversial. In a 5th video published on December 22nd, 2022, Quest claims that Rekieta referred to him as a retard, challenged him to file a lawsuit stating that Quest's reputation was so poor there could be no damages. Yeah, I think that's true. And I'll show you kind of one of the big problems that Quest has with this. It's related to damages. Finally, Quest claims that Rekieta further referred to him as a retard in a video published on January 11th, 2023. Now, again, that was my ADA provided retard. And I've got to say, like, as a testament to myself, that's one of the funnier jokes I've ever said to be put in a lawsuit. That the Americans with Disability Act enforcement arm assigned me a private retard. That got put seriously in a lawsuit is one of the funniest fucking things that I've ever seen. Like, that's hilarious to me. Holy shit, that's funny. I got to take a moment. So, Quest alleges that the statements made by Rekieta on these 6 occasions injured his reputation and character so as to negatively impact his relationship with others in his community. Quest does not provide specific examples of this injury. And this is the big fucking problem with his case. Where is Monty going to argue that he's damaged at all? Where can he make that case? Montagraph's Social Blade, which I'll bring up, has a big problem here. Montagraph's Social Blade. So we stop screen, we present this. So first of all, monthly gain video views from Montagraph. Now this is really interesting. So Montagraph has negative 1.9 million views from January of 2021. He has negative 833,000 views in January 2022. He's got negative views here. Negative views are where you delete videos. So I don't know if he deleted them at these points. I think that's what it means. But then his video views are roughly, he's got negative views here. He's got negative views here. That means he deleted videos because you don't get negative views. It's not possible. But past 2 months, May and June, lots of deleted views. Do you get negative money? No. Now, Social Blade just uses API to see the total view count on the channel and follows it accordingly. If you private or unlist a video, it removes the total view count from your YouTube channel. If you relist the video or unprivate it, it will add those views back in that you had. Because the API is only what YouTube data provides. So it provides a total view count. That's what Social Blade scrapes. They don't have the ability to tell you where the views came from on Social Blade. So he doesn't actually have negative views. He has removed videos. Now, why he's been removing videos during our lawsuit, I couldn't tell you. It could be any number of reasons. I have no idea, and I won't speculate. But I have some theories. I have some theories that won't air publicly. You can all decide for yourself. I mean, maybe he has a legitimate reason for privating videos. I don't know. Doing it during the pendency of a lawsuit that he brought, a little bit interesting. 1, 2, 3 months of negative video views. Now, he could be trying to show damages, I guess. But that's going to be tough to show damages when you're specifically impacting your views. You can't actually get negative views on a channel. Now, the other problem he's got is here's his monthly gain subscribers. Now, again, all of the allegations are from October of 2022, moving into January of 2023 at the latest. So he gained 200 subscribers flat in November, December, minus 100. Now, the way YouTube counts stuff, if you don't know, is depending on how many subscribers you have. So if you have 5 figures of subscribers, it goes down to the 3rd significant figure. So if you have 10,099 subscribers, it will count it as 10,099 until you get 10,100. Then you'll gain 100 subscribers on Social Blade, because Social Blade can only track to the last 3 significant figures. If you have 100,000 subscribers, it will track to 999, and then gaining 1 more is plus 1,000, losing 1 is minus 1,000. So if you go from 101,000 to 100,999, you lose 1,000 subscribers on Social Blade. All right. So he loses 100 subscribers in January, 0 subscribers in February, in March, plus 200 subscribers, minus 100 in, or wait, no. Shit. Loses 100 subscribers in December. 0 subscribers January. Plus 200 in February. Minus 100 in March. So again, this could be anywhere between 1 and 99 people. Flat in April. May is flat. And then June is minus 100. Montagraph has to show damages from this. And he has to link those damages specifically to statements that I made to show damage. He's got a tough thing to do here because he hasn't lost anything. I mean, his trend of subscribership is the same leading up to the statements as it is following the statements. He's going to have a hard time showing damage. It's a big problem for him, even on the defamation per se. You can win on defamation per se, hypothetically. You still have to link damages to win a recovery from it. So these are big things from that. He'll have to figure out. So anyway, so that's on damages. So I just wanted to point that out. He's going to have a real tough time doing that. Specifically, he's going to have a tough time showing damage. How is Montagraph damaged at all? By being the exact same that he was before. And then the second would be linking those damage specifically to me making fun of him on my videos, which he then monetized for personal gain. He monetized his dispute with me for personal gain on live streams. So he's got this other problem where he directly financially benefited from it by his choice. He's going to have to show how he was harmed. Tough road ahead, Monty. Rekieta's brief in support of his special motion to dismiss admits that he referred to Quest on these various occasions as a faggot, retard, pedophile, and that he is into sucking little boy cock. He doesn't dispute that he claimed Quest directed a snuff film named Little Piggy and the Umbrella Man. I mean, that's a true thing, in which he starred alongside a minor child. Well, someone represented as a minor child, I think is what we said. Defendant's brief, February 14th at 6 to 10. On the IMDb page for the film, Montagraph is listed and credited as the director and the actor playing the rapist. In the October 28th, 2022 video, Rekieta addressed Quest directly, stating that he has an image problem. He does. He does. A ton of people who are not me consider Quest to be a pedophile, a rapist, a monster, all of those things. Because, like, again, I had not really heard of Montagraph prior to Jim bringing up the video of Montagraph filing a phony, frivolous lawsuit against a guy named Morphinos for the same things. Montagraph has a fucking image problem. Let's be real here. I have an image problem. I've done numerous things to give people plenty of reason to not like me, to think poorly of me, to think I get what I deserve, they create stories about me even, and I can't refute the stories they create. One, you can't change people's minds like that. And two, you know, I've said enough dumb shit in my life to give people grounds to call me just about whatever. That's part of being a quote unquote shock jock. It's part of being online all the time and live. There's no recovery from live video. Like, you say something and it sticks. Whether you meant it or not, whether it's true or not, whatever, you say it and it's there. And people are free to comment about it because you're a public figure. Of course they can. Of course they can. I'm talking about this a lot because if someone accuses you of something, you can't deny it. There's no denial that is sufficient on the internet. Like, you can deny it, like you can try. And they'll go, but yeah, I don't believe you. Okay. What's the fight against that? There isn't one. Montagraph has an image problem. He did the whole melon fucking thing, which they left off of here. He did the Barbie 2 girls 1 cup thing, which is weird. He directed the Umbrella Man, which is very unsettling to a lot of people. He had discussions about photographing nude minors with his Montagraphy, his photography business called Montagraphy. All of that's been discussed on the internet. I have no reason to disbelieve any of it. He has an image problem. Maybe it's not a problem, right? Like Andrew Tate has an image problem. He's wildly successful and famous. I mean, he's got problems in Romania right now. But other than that, like, people get to say what they want about Andrew Tate. He's got an image problem, I think. I wouldn't want Andrew Tate's image personally. It's not my thing. I disagree with him on a shitload of stuff. So, Ethan Klein has an image problem. Makes a shitload of money. Mr. Beast has an image problem. So this is a weird statement that they're latching onto. You're on the internet and you're talking to people on live streams. You've got an image problem. First of all, if you're live streaming on the internet by yourself, you haven't been hired by someone. I don't care how notable you are, or how many people you have. You're a fucking psychopath. Tim Pool, Aisha Speed. Because part of what attracts people to online personas is drama, insanity, this idea that this person is not normal. Like they're interesting. They're interesting as a train wreck, or they're interesting as like a success story and inspiration. It's going to be different for everybody. This is, to me, I mean, it's not a controversial statement at all. But Montagraph clearly has an image problem. There's decades of chatter, or, well, I shouldn't say decades. There's a decade of chatter about Montagraph being a pedophile, about him being a weirdo, about him being insane. All of that stuff is out there. It's been out there long before I said anything. Additionally, he referenced his past statements regarding Quest's potential pedophilia, saying that the kid stuff was joke stuff. I mean, I said that on stream, and that a reasonable person could form the opinion that Quest is a pedophile based on Little Piggy and Umbrella Man. Well, yes, people have formed that opinion, but not just based on that. That's partial. Also based on a whole lot that Quest has said and done. A whole lot of it. Standard of law. Rekieta brings a special motion to dismiss under Colorado Revised Statute 1320-101, an anti-SLAPP legislation that aims to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government. Essentially, this law attempts to discourage meritless lawsuits that would otherwise discourage individuals from participating in free speech in public life, like this one. Pertinent to the case, Colorado statute provides defendants who make any written or oral statement of writing made in place open to the public or public forum in connection with an issue of public interest, or any other conduct or communication furtherance of the exercise of the constitutional right of petition or the constitutional right of free speech in connection with a public issue or an issue of public interest. Now, personally, I think that Montagraph's statements and his calls to government officials and all the weird shit that he does are certainly of public interest. Also, I think his calls to murder people like me, again, Jack from Twitter, stuff like that, I think those are public interest too. So, you know, I think that applies, but okay. Further, the statute provides the court must determine whether the plaintiff has established there's a reasonable likelihood and the plaintiff will prevail on the claim, which I think there is here. There is scant Colorado case law addressing anti-SLAPP motion analysis. Only one trial court order provides a framework for addressing it, and it adopts California law due to the similarity between Colorado and California anti-SLAPP statutes. In this analysis, quote, the trial court engages in a two-step process. First, the court decides whether the defendant has made a threshold showing that the challenge cause of action is one arising from protected activity. If the court finds such a showing has been made, determines whether the plaintiff has demonstrated a probability of prevailing on the claim. It doesn't actually matter here because she finds that the Colorado law doesn't apply anyway. Rekieta admits that even if the court applies Colorado law, this special motion to dismiss is practically equivalent to a motion for summary judgment. Summary judgment is proper if there are no disputed issues of material fact and the moving party is entitled to judgment as a matter of law. In considering a motion for summary judgment, a court cannot weigh the evidence, make credibility determinations, or attempt to discern the truth of the factual issue. Okay. To defeat a motion for summary judgment, the opposing party must set forth specific facts showing that there's a genuine issue for trial. Court must view the evidence in light most favorable to and making all reasonable inferences for the non-moving party. Conflict of law exists between Colorado and Minnesota regarding anti-SLAPP statutes. Correct. Minnesota has ruled their anti-SLAPP statute unconstitutional for the reasons that it basically deprived people of a right to trial based on how it functioned. Now, the Colorado one is significantly different because the Colorado one is a summary judgment analysis rather than a motion to dismiss analysis, that's the different thing. And I'm actually not a big fan of the motion to dismiss versions of anti-slaps. They don't provide for an adequate review of the evidence, in my opinion. They provide a heightened standard for plaintiffs than regular lawsuits do. And I think they do. I think anti-slaps do shut down otherwise non-frivolous defamation lawsuits in states that have them when they have that analysis. And the Colorado one is different. I don't fully know if I agree with it or not, but the Colorado one is different because it provides for summary judgment analysis, which is a weighing of the evidence, but not the validity of the evidence. All right. And it doesn't provide a heightened burden for either party to overcome to move to victory. Whereas an anti-slap provides a heightened burden for the plaintiff over regular pleading. So there are different measures of anti-slap. And my anti-slap problem is not so much with the concept of it. It's with having a special, again, it's a special statute that has a different standard. I actually think that anti-slap exists baked into motions to dismiss, motions for summary judgment. That's my personal opinion. I don't think this anti-slap statute is necessary. I think the remedies are already present. But yeah, so whatever. Both parties acknowledge that Minnesota previously had an anti-slap statute that was found unconstitutional by Minnesota courts in Leindecker versus Asian Women. Why would you fight Asian women? And Mobile Diagnostic Imaging versus Hooten. The court in Mobile Diagnostic explained that Minnesota's anti-slap statute cannot be applied in a manner consistent with the constitutional right to a jury trial because statutes requiring pre-trial factual determinations require the court to step into the role of the jury. Now, again, motions for summary judgment do not require the weighing of evidence. They say, we admit for the purposes of this motion to all of the evidence that's there in the light most favorable to the non-moving party, and we still say that we win. That's a summary judgment motion. The dismissals through anti-slap do tend to weigh evidence one against the other. That's an issue. Now that Minnesota has found its own anti-slap unconstitutional, Rekieta appeals to Colorado law. Of course I do. In cases where the relevant law is in dispute, the court must employ a choice of law analysis to decide which to apply as a threshold matter. When deciding choice of law issues, the district court sitting in a diversity action generally applies choice of law rules of the forum state. In Minnesota, the first step is resolving a conflict of law, determining whether choosing laws of one state over the law of another state would be outcome determinative. In this case, because Colorado has an anti-slap statute that provides defendants with immunity for defendants exercising their First Amendment speech rights, and Minnesota doesn't, choice of law outcome is determinative. Yes, very much. Once a conflict is found, Minnesota courts evaluate 5 choice influencing factors. 1, the predictability of result. 2, maintenance of interstate and international order. 3, simplification of the judicial task. 4, advancement of the forum's government interests. And 5, application of the better rule of law. These factors are not overwrought rules, but rather tools to help the district court grapple with each individual situation. Quote, while prior opinions may be helpful to a court's deliberations, the court's obligation is true to the method rather than to seek superficial factual analogies between cases and import wholesale the choice of law analysis contained therein. This line is what the internet would call a cope. This line is because the superficial factual analogies to our case would support a finding of the Colorado anti-slap law. But it says that those superficial factual analyses are not how the analysis is done. So we have to go with the judge's analysis. And this is ultimately one of the problems mentioned with appeal. The district court judge here is given broad discretion, specifically in the language of the controlling case. The controlling case says you can't just go by precedent. You can't just go by what other courts have done. You have to make the determination based on this case. Well, when an appeals court says that, and the Supreme Court of Minnesota says that, what they're saying is we're going to defer to the judge who's sitting in front of this evidence, who's sitting in front of this case, and overturning them is going to be probably, I don't know, but I'm going to guess, an abuse of discretion analysis. An abuse of discretion is really hard to win. You have to show that the judge did something outside of their discretion, which she may have here, but I don't know. Again, I can't argue the choice of law thing. It's not my expertise at all. I've never had a choice of law case. Anybody knows that my case record is scant. I'm a much more experienced entertainer than I am a lawyer. That's never been false, even when I first started YouTube. If I wanted to continue being like the greatest lawyer ever, I would have chosen a vastly different career path than opening my own shop in the middle of nowhere, Minnesota, and dealing with like petty crime cases. And my main draw is that I can take the language of the law, my main legal draw, other than my dashing good looks and massive shoulders. My main legal draw is that I can translate the inaccessible realm of legalese into English with some comedy thrown in. First, predictability of result embodies the ideal that litigation on the same facts, regardless of where litigation occurs, should be decided the same to avoid forum shopping. This factor applies primarily to consensual transactions where the parties desire advance notice of which state law will govern future disputes. So that's where she's going to go on this. While it is possible that forum shopping occurred in this case, it absolutely occurred in this case. There's no way that Montagraph's thinnest fucking argument that he does business occasionally with some website in Minnesota has anything to do with him having damages in Minnesota. Where, like, did the website drop him after these statements? Like, did something happen where Montagraph can no longer do business in Minnesota? No, of course not. But he says that. So obviously forum shopping occurred, with Quest choosing Minnesota as a forum state due to lack of an anti-SLAPP statute. There's not a consensual transaction in which the parties could have anticipated a need or desire for advance notice, right? That's that second part. I disagree with this. Because the statements I made about Montagraph were not made in a vacuum. And if we appealed, this was mentioned, I believe, in our motion, but if we appealed, I would imagine we would put in, Montagraph came to this party. Montagraph came, like, I didn't speak about Montagraph out of nowhere. He came in firing at me. Like, that was what happened. Again, I don't think about this guy and hadn't heard from him in years. I had no idea. Montagraph came in firing at me after firing at me a whole lot for me just being on stream with Jim. So, like, the idea that this was not a consensual transaction, whereas I'm openly in Minnesota, very obviously in Minnesota, lawyer in Minnesota, open every show, small law firm in central Minnesota. I would argue that it was a consensual transaction on Montagraph's point, but that wasn't part of our specific argument in our motion. So I maybe we couldn't even bring that up, but I think on appeal, you'd have to argue it. Whether the appeals court, and this is a thing with appeals, right? You're not really allowed to make new evidence and new arguments before an appeals court. Now, you could argue that you have the evidence in there that this was a consensual transaction, that the Montagraph came in, because we did mention it specifically. The Montagraph came in, that he was firing at me and I fired back. So you make the argument that it's consensual, but the counter argument to that would be that consensual transaction literally means a business transaction, and it's not related to a back and forth retard slap fight, right? So again, this is one of those questions. Do you go to appeal on this issue? You can make an argument, but there's also a good counter argument. So do you weigh that out and you decide what to do? And again, for anyone looking for what I'm going to do next, I can't tell you. I don't know. I don't have an answer. I've got time to think about it and a lot to think about. And right now I'm thinking about pretty much everything else. But yeah, so there's an argument either way on this, like most things in law. And what the strength of the argument is going to be, tough. I mean, if they're talking about business transactions, that's going to be a tough one. If they're talking about consensually entering into a virtual arena, well, that's a different story. Because I didn't invite Montagraph to my streams. Again, I forgot he existed. There was no agreement of anticipation for further relationship here. The parties did not voluntarily associate. I mean, I didn't, but Montagraph did. And then I engaged him, so maybe I did. I don't know. Instead, they were thrust into contact through public discourse and live stream chats. Thrust into contact is a weird one. I was. Montagraph wasn't. Therefore, this factor favors applying Minnesota law over Colorado law. I mean, again, I'm not an expert on this. I obviously think it favors Colorado law. I'm biased, though. So I'm not going to call out the judge on any of these things. I'll tell you my thoughts on it, but I can't disagree with the judge personally here. My lawyer might, right? My lawyer who does this as his main profession on a national level, he might disagree. I don't know. I can't agree or disagree because this is not my field of study. So I want to be very clear because I know people are going to be like, oh, Nick said this and this. It's like, no, dude, I literally don't know. Again, I wouldn't have even made this argument because I wouldn't have known to make this argument in the first place. So I'm not going to sit here and be like, this is how it should work. Second, maintenance of interstate order concerns, whether the application of one state's law would manifestly disrespect, would manifest disrespect for another state's sovereignty or subvert its interests. Evidence of forum shopping or that application of Minnesota's law would promote forum shopping would indicate such disrespect. Absolutely, this is Colorado law here. In this case, applying Minnesota law could certainly incentivize forum shopping, allowing plaintiffs from states with anti-SLAPP statutes to file in Minnesota. Since Minnesota found its anti-SLAPP statute unconstitutional, defendants do not have statutory immunity against claims intended to show the exercise of their First Amendment rights. If the plaintiff were to attempt to intimidate a defendant through legal action, Minnesota is a preferable forum to Colorado for this reason. As such, this factor falls in favor of applying Colorado law. That should be obvious to everybody. Like Montagraph obviously forum shopped this. The third factor is often considered insignificant because courts can as easily apply another state's laws as their own. Although insignificant, this factor weighs in favor of applying Minnesota law because the judicial task is obviously simplified when a Minnesota court applies Minnesota law. So sure, but it's insignificant. Fourth, advancement of the forum's government interest involves analysis of whether choice of law would affect a significant interest of the forum state. Now, I almost agree with her here, except one big thing that we're going to get into. This factor ensures that Minnesota courts are not required to apply rules of law inconsistent with Minnesota concepts of fairness and equity. Applying Colorado law here would contravene Minnesota's interest in fairness and equity. I disagree. It isn't that Minnesota has never enacted anti-SLAPP legislation. It did. However, Minnesota decided that the statute was unconstitutional. Again, but the statute was vastly different than that of Colorado's. And the reason it was unconstitutional is not present in the Colorado statute. So here I'm going to disagree. This isn't a case where another state's law can fill a void that was never legislated. No, actually, interestingly, again, not an expert. This is my own personal take, my own personal argument. I don't even know if my lawyer would agree with this sentiment. He might. I don't know. This was legislated. This was found to be relevant to Minnesota law, and a different portion of the statute was found to be unconstitutional, and they ruled the whole thing unconstitutional because it was not severable from the statute itself. That does not mean that this issue was legislated and found unconstitutional. This issue was not. This issue was not. A different issue was. So I would disagree here. But again, personal disagreement, highly biased. Whether or not that would be a winning argument, I don't know. All right. Minnesota courts have spoken clearly that anti-SLAPP legislation is unconstitutional. No, again, the specific method by which our anti-SLAPP legislation was enacted, abrogating an individual's right to a trial when it requires pre-trial factual determinations, which we haven't asked for here. As such, Minnesota has made a determination anti-SLAPP statutes are suspect. This interest is particularly strong because it implicates an interpretation of a constitutional right. Applying Colorado law would disrespect that interest in Minnesota's constitution. I disagree for the reasons laid out in our brief that this is a sufficiently different law than Minnesota's and does not touch on the unconstitutional aspects of Minnesota's. As such, this factor weighs in favor of applying Minnesota law. But I mean, I see her argument. Obviously, I disagree. Bias. I want to resolve this case and move on with my life. But that being said, I see her argument. I just mildly disagree with her reasoning. Finally, the fifth factor is irrelevant here because this factor applies only when the first four factors do not clearly resolve the choice of application in Minnesota, not Colorado law. While there is some risk of forum shopping, I mean, it's obviously forum shopped. Colorado law does not advance Minnesota's government interest, does not support predictability of result, does not simplify the judicial task. Even though Colorado law does not apply, however, both parties essentially address this motion as a summary judgment motion. Therefore, taking this motion as is treated by the parties, Rekieta may still be entitled to summary judgment under Minnesota law. Still true even after this order. Rekieta is not entitled to summary judgment on defamation at this time, is left off of that. Regardless of the other vulgar names that Rekieta directed at Quest, the accusations of pedophilia are the most valid claims of defamation because they are defamation per se. Statements are defamatory per se if they falsely accuse a person of a crime, of having a loathsome disease, or of unchastity. Following this rule, courts have held that statements accusing a person of serious sexual misconduct are defamation per se. Again, Minnesota is at odds with a large portion of the country here. And this case is from what, 1983? No, 2007. It's from 2007. In determining defamation, which is still pretty old, in determining defamation per se, the court must analyze, quote, whether a reasonable person in similar circumstances would understand the statement as making an accusation or imputing criminal or serious sexual misconduct to another. Now, we have laid out, my lawyer has laid out the argument for why that is not the case here. For a couple reasons. One, it's his reputation already, and reasonable people would find that based on his, again, his alleged photography of nude minors in his Montagraph business, the Umbrella Man movie, other statements he's made. There's several articles about Montagraph being a pedophile. We've put them into evidence here. All of that. So, dude's a fucking weirdo. He's a weirdo. But let's see. The reasonable person standard in this context is a question of fact. And this is why denying the summary judgment thing. But that's not the only issue here. Even though Rekieta acknowledges videos that his statements regarding Quest's kid stuff were joke stuff, the strong language of the case law supports construing the accusations of pedophilia as defamation per se. In almost every circumstance, a reasonable viewer would understand these accusations of implications of sexual misconduct and criminal activity. This is a fact question for the jury to determine. Therefore, there is a disputed material fact that precludes summary judgment on Quest's defamation claim regarding Rekieta's statements that Quest is a pedophile. Now, this is actually a very troubling sentence for me, because this may imply that I'm not eligible for summary judgment at all on this specific statement. Now, I don't think that that's proper. And I think that a subsequent motion for summary judgment would specifically be focused on addressing that issue. But that's how that could be read. That is not a good indicator for me in my case. Again, so here's the thing is going through analyzing this as fairly as possible, noting my own biases and arguing specifically against them. That is definitely a way to read this. I know people thought I was going to come out here and be like, this is all dumb and blah, 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 blah. I don't have any reason to do that. Rekieta is not entitled to summary judgment on Quest's claims of intentional and negligent infliction of emotional distress. In Minnesota, emotional harm resulting from a defamation claim requires that there be some reputational damage. Minnesota courts have exercised historical caution regarding emotional distress claims, and emotional damages are not compensable absent harm to reputation. In short, there's a reputational damages prerequisite to emotional distress and actions for defamation. At this point, Quest has shown no reputational damages. The only evidence of reputational damages on the record is a video supposedly showing Rekieta devotees following him. This video, this is almost sanctionable from what I understand. Like, this video, if I'm not mistaken, is from before I had even heard of or mentioned Montagraph ever. And presenting it as evidence is exceedingly dubious. There's no connection of me to this video at all. And first of all, like, it's insane. It's a fucking insane thing. It's made by a guy who's cataloging Montagraph forever before I existed, even on the internet. Like, before I was even broadcasting, this guy was cataloging Montagraph. A reminder that Montagraph has been tormenting people online for years and has developed a bad reputation. So them suggesting this was me is just silliness. But hey, I mean, what's lying to a court, right? The video, however, does not show a person trailing Quest. It does not contain evidence that this person has any connection to Rekieta, and it doesn't even show Quest. The lack of evidence of reputational harm at this point in litigation, however, may be cured through the process of discovery, which is yet to conclude. Now, this is the part I really wanted to talk about with this. Why do we need discovery to determine information that only Montagraph would have? What is the purpose of discovery? Is to provide a judicial tool to obtain evidence possessed by the other party under law that you are entitled to. I don't have evidence of Montagraph's reputational damage. I can't have evidence of Montagraph's reputational damage. I can show where I don't think his reputation was damaged at all through things like Social Blade. Through, I guess I could submit, copies of things people have said to me about Montagraph, and I've got them, I guess. So this is something that Montagraph has not submitted, and they should have submitted as part of this summary judgment process, but they didn't. And a discovery window isn't necessary. They can't get that information from me. It has to come from him. And he's had ample opportunity to present it. He brought this case in December. 7.5 months. So where's the damage? What is it, Monty? It's on you. What is it, Schneider? You wouldn't have brought a frivolous case, would you? Oh, that'd be silly. That'd be bad, right? Like against your ethics or whatever. So where's the damage? I don't know. But again, the judge has determined we need discovery for them to post their own stuff. The discovery tools are not going to elicit Montagraph's reputational damage from me. They have to come from him. He's got a hard time showing it. That's their problem. That's why they haven't submitted the evidence in this case. Because if you had the evidence, right, for summary judgment, you would just submit it. Like if you think that this is a summary judgment motion, if we lose on this at all, we got to put it out there. And there's no reason to hide it because summary judgment doesn't weigh the evidence in favor of one against each other. It takes the evidence in light of the most favorable to the non-moving party. So they have every reason to have submitted this already and didn't. This is where I have the biggest disagreement with this judge on this issue. It's that saying we have to wait for discovery to get information that the plaintiff has beneficial to the plaintiff is weird, because the plaintiff should have presented that at filing. It's one of the requirements for proving out their claims, or they should have presented it at the summary judgment stage. And they don't have to get it from me. They have to get it from him. Rekieta's summary judgment motion is premature. This never happens. Oh, I'm sorry. Adequate time for discovery is essential to ensure that potentially meritorious claims are not unjustly thrown out before the non-movement has had the opportunity to produce evidence that could defeat summary judgment. I mean, they've had that. We don't, like, they don't need discovery to get this information. That is the critical element that's missing from this analysis. It's illogical. As a general rule, summary judgment is proper only after the non-movement has had adequate time for discovery. Again, it's relevant to what you need to produce. In this case, he needs to produce evidence of damages that only he can have. And in the present case, Quest opposes summary judgment on this ground, claiming that Rekieta's motion is procedurally defective and that summary judgment cannot be supported at this stage of litigation because the factual record has not been adequately developed. This is correct. Although Quest has not yet provided substantial evidence to support a finding of reputational damages, there is a possibility that he could before the window for discovery closes. Oh, okay. I mean, I guess. How? That's insane. All right. Rekieta's accusations of pedophilia were severe. They didn't damage him at all. We can show in real time that he hasn't suffered any damage from it. Even if they were made with comedic intent and tone. Even if they were made with comedic intent and tone, makes them necessarily not defamatory, which then defeats the intentional infliction. So what I'd said before about like the defamation per se being a strong line in favor of Montagraph, this is similarly made with comedic intent and tone, and then hearkening back to their admission that my show is comedic and hyperbole, along with my acknowledgement that I'm something of a shock jock. All of those things go heavily in my favor on this. So this is a nice statement to the contrary. They are the type of accusation that would inspire anger, distrust, and negative consequences for their target. Until further discovery is conducted, summary judgment is improper. Therefore, this motion for summary judgment is premature. It is denied so that the parties may further develop the record. Okay. Rekieta's special motion to dismiss is denied. First, it is denied with regards to count 1 of the amended complaint because Colorado does not apply in the present case. Rekieta is not entitled to summary judgment on Quest defamation per se claim. When there is a choice of law issue in Minnesota, the court must first find a conflict of law and must evaluate 5 choice influencing factors. Most of these factors favor applying Minnesota law in the present case. Minnesota accusations of pedophilia are traditionally treated as defamation per se and are tested by the reasonable person standard as to whether an average person would understand the accusation as truthful. I mean, I don't know. Again, 1, based on his reputation, and 2, made in a obviously drunken vocal clash, insults flying back and forth on a comedic podcast with shock jock elements. That's going to probably be the basis for the argument on the renewed motion for summary judgment. Whether it'll prevail or not remains to be seen. This standard is treated as a question of fact for the jury that cannot be decided on summary judgment. Maybe. Therefore, Rekieta is not entitled to summary judgment under Minnesota law on Quest defamation claim. Neither is Rekieta entitled to summary judgment on Quest claims of intentional and negligent infliction of emotional distress. In order to prevail on claims of intentional and negligent infliction of emotional distress, a plaintiff must show they are suffered reputational damages as a prerequisite to emotional damages. This stage of litigation before the close of discovery, there's no evidence of reputational damages. Further discovery, however, may cure this defect by providing evidence that Quest indeed suffered damages. Therefore, this motion is premature, inappropriate to grant summary judgment with regard to Quest claims of intentional and negligent infliction of emotional distress. Though it is currently inappropriate to grant summary judgment may be reconsidered once further discovery has been conducted. So There we go. So the good of this is it's considered premature. The bad of this is there is a reading that says the judge precludes all summary judgment on what she claims a defamation per se statement. Now, again, I'm going to go ahead and disagree, but that may not amount to much. What is a certain possibility is winning on summary judgment entirely, winning on the infliction of emotional distress claims, all of the other allegedly defamatory statements, but going to trial on the one specific statement, which would then require a showing of Quest's reputation in the community as a pedophile, which we've provided. But again, courts are not allowed to weigh evidence at summary judgment. So that evidence would be weighed by a finder of fact, either a judge or a jury trial, which would be absolutely fucking ridiculous to see. But hey, my life gets to be ridiculous sometimes. So if we have to go into court and show a bunch of people that Montagraph is a horrific monster, well, then I guess that's what we'll do. I don't wanna. Okay, I don't want to do that. But if I have to, it'll be funny. At least it will be funny. And guess what, guys? Like, it's all at my expense for your entertainment. And not just at my expense, of course. Grift time is here. You can go to GiveSendGo/Rekieta Law if you want to help pay for the cost of this litigation. Again, I had already paid a massive amount of money before opening the GiveSendGo. And importantly, no one has to give a single dollar. I will pay every single penny of this litigation. YouTube, you guys, Rumble, locals have been so amazingly generous to my entire life that this is my burden to bear. I'm an asshole on the internet. I'm not absolving myself. I'm surprised it took this long, to be honest. But some people expressed desire to help. They wanted to be a part of it. If you want to be a part of it, go to givesendgo.com/Rekieta Law. If you do not have the money to support it, or if you don't like the idea of giving me money for this lawsuit, or if you think I deserve it, or if you think whatever, think I made enough money. I made a lot of money on streaming. I've never made bones about it, never pretended to be poor or destitute, ever. And I would never do that. I would never, ever pretend that I need help. But I appreciate it. It is really expensive. But I'm financially blessed. And I won't do the fucking irritating YouTube grift where there's someone who makes hundreds of thousands of dollars a year misrepresenting that they're going broke based on this lawsuit that they just really need fans to support. I'm not going to do that. Make a very, very good living. So if you want to support it, you can. That's always what the Give Send Go has been about, for people who want to support it. And it's GiveSendGo/Rekieta Law. But please, 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 if you have any reservations about anything I've said, if you have any minor financial hardship to major financial hardship, do not give me a penny, please. Please do not. I've never, ever been about the idea of begging for things. I really struggled with opening the GoFundMe or the Give Send Go in the first place. But a lot of people asked me to do it. People have been very, very generous on there, and I thank them so much for that. But it's not about the ability to pay. Believe me, there are many things I would much rather spend money on. My kids, myself, like 700 baldos, whatever. But I'm going to live. I'm going to live. It'll be just fine. And the most important thing for all of this is that it's entertaining for you guys. That's what I hope. So, probable cause says the judge is clearly wrong on the premature thing. Nick's way too late and gay to be early on anything. That's true. That's a fact. It's a fact. So that's that, guys. That's the order. Believe me, when I got it, I was kind of bummed. Not a big fan. I rate it 3 out of 10 on like the this is great scale. But that's it. What I can say is I have one of the best defamation lawyers in the country. So there's that. But the law is the law. Judges are real. They have different reads on things. I don't know. Again, so the options at this point, are simple. You have something called an interlocutory appeal. So an appeal typically takes place at the resolution of a case. You go, the case has to fully resolve, and then you appeal the outcome of the case. An interlocutory appeal happens at a stage of the trial where someone is denied, how do we put this? They're denied definite relief. They're deprived of a right to relief from an issue at this stage. So the interlocutory appeal would be the defamation per se finding, questions of evidence that are in the record as far as reputational damages, the purpose and scope of discovery that would allow that evidence to come in, whose burden it is, and then finally the application of Colorado law versus Minnesota law. Now, on the application of law, you're going to get a massive favor of the judge's decision here because it's a factor that's weighed in favor of the judge. So you're going to get abuse of discretion as a standard. And you're going to have to find that the judge was clearly incorrect on the law and abused the discretion that they had to support that incorrect finding. That's not going to be easy here because it relies on the trial judge's determination. They're going to get deference on it. So it's a really tough one. The finding of defamation per se, you would have to argue that, basically the statement was made comedically, exchange, was not intended by any reasonable person to be taken seriously, all of that stuff. You'd have to argue that. Would you win on that? I don't know. I mean, I think the nature of online discourse, the more mainstream application of the pedo name, all of those things are arguments that you would make, still are going to, that's going to be a question of, do they overturn this older ruling or distinguish from the older ruling that exists? Who knows? There's plenty of support, again, from other jurisdictions, but those are other jurisdictions, so bring that in. And then finally, the premature thing and the discovery time. I think that one is winnable, mainly because discovery as a function doesn't serve to actually fulfill the missing piece of information. It's defective from the plaintiff's side. The plaintiff is a non-moving party, but they've had opportunity to support with evidence their own pleadings, which they haven't done. So you can probably win on that one. The first two are very iffy. So the other option is to go through discovery. We have a scheduling conference coming up in August, and going through the discovery, or finding out what the discovery window is. And in that case, there would be potentially requests for information, requests for admissions, interrogatories, and ultimately possibly depositions, which I know many of you would love to see me deposed. And as funny as it would be, I don't really want to pay for depositions. They're very expensive. but it'll be fucking funny. Oh, and if so for anyone who looks at this and goes, "Oh, Nick is completely wrong in the law," blah 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 blah, I would implore you to check out someone that I find personally like very goofy, who does not like me at all. Does not like me at all. Don't take my word on this. I mean, this is my word. Again, I've admitted my biases. They should be evident, but admitted that I do have them very openly and obviously. Go look at what Mike Dumford, who I think is a complete dope in general. Look at what he says about this case. And he hates me. But even he sees how frivolous this bullshit is. Because of course it is. It always was. But yeah, don't take my word for it. Take the word of people who have hated me for years. All of that being said, that's the update on the lawsuit. It's the update there. I think it's pretty fair. We went through every word. Judge for yourself. You think I'm an asshole who deserves to pay Steve Quest for calling him, for saying he always liked to, he maybe, I said, I think I asked him if he always liked sucking. No, I said, you probably always like sucking little boy cock or something like that. I think that's what I said. Probably did. I don't know. Did he not? I don't think he's denied it yet. But yeah, if you think I deserve to like be liable to Montagraph for that statement, you know, that's fine. I don't. Dude's a fucking weirdo. I'll stand by that forever. But you know, who knows? Who knows? Thank you for hanging out and watching. Even if you hate me, like, look, it's the internet, man. I'm plenty used to people who don't like me, don't approve of my decisions. It's fine. You know, you get to say whatever you want in chat. It's cool. But this is the reality of it. There's no way to approach it other than the way that I'm going to do it. It's if it's someone else's case, you know, it certainly would have more fun flair to it, more jokes, maybe like yelling and stuff at the judge. But you can't do that in your own case. It's ongoing like that. That's not going to be profitable, even if it's funny to do so. So kind of constrained in that respect. But I have disagreements with the judge, obviously, and there's plenty of stuff in this ruling that's agreeable. But we'll see what the next step is. I will, of course, keep you guys posted as we go. But I think the next thing in this case is not until August with our sentencing hearing, or not sentencing, scheduling conference. There was going to be here in July. I think it was going to be today or tomorrow or something. But now is pushed back to August. So I won't know anything really until then. On what the next steps are, unless if we filed an appeal, I think it's got to be within 20 days or something. Don't quote me on that. I'm not 100% on the rule off the top of my head, but it has to be. I think it has to be potentially sooner than that August hearing. So if we're going to do that, there would be a filing. I don't know if that's the answer or not. Got to talk to my attorney about it. Consult my psychic. Shove a rod of tungsten up my ass and pretend that I'm on a satellite owned by Joe Biden and Elon Musk and their baby. So before I can make that decision.